Get ready. 3 seconds. 2 seconds. Start. This appeal against the conviction has been filed against the concurrent findings recorded by the trial court and the High Court for a double murder committed on 7/10/1990, for which the appellant was sentenced for life on 2 counts, both sentences to run concurrently. As per the prosecution story, the father and brother of the first informant were murdered during the night of 7/10/1990 in their house. The first information report was lodged by Munda at police station on 8/10/1990, alleging that during his absence from the house, some persons had murdered his father and younger brother. During the course of the investigation, the police recorded the statement of various witnesses, including PW1 and PW2, PW5, the medical officer who had conducted the postmortem on the 2 dead bodies, PW6, the informant, and PW7, who was a neighbor of the deceased and to whom the accused had made an extrajudicial confession on the death of the murder itself, and PW12, the investigating officer, who was also a witness of the recovery of the murder weapon at the instance of the accused. The trial court and the High Court have both noticed that as the solitary eyewitnesses had died and the other 2 material witnesses, PW1 and PW2, had been declared hostile, the prosecution story rested exclusively on the confession made by the accused to PW7 and the factum of recovery of the dowry at the instance of the accused before PW12, the investigating officer. At the hearing before us today, Mr. Pranit Ranjan, the learned amicus curiae for the appellant accused, has argued that the only evidence against the accused was the extrajudicial confession made before PW7, and as this evidence was a weak kind of evidence, the conviction of the appellant could not be maintained. He has further submitted that the police had in fact used third-degree methods and tortured and threatened the witness to give false evidence, and as such the case against the appellant appeared to be a concocted one. The learned counsel for the state of Assam, however, has supported the judgment of the court below. It is true that an extrajudicial confession is a very weak piece of evidence, and ordinarily a conviction solely on the basis of such evidence cannot be maintained. The confession made by the appellant to PW7, however, falls in a different category. A reading of the evidence of PW7 clearly reveals that her house was about 100 yards away from the murder site, and that when she had come out from her house to throw the stars out of the cooked rice, she had seen 3 persons running away from the house of the deceased, and that a little later the appellant accused had come to her house carrying a dowry and addressing her as Didi. Didi had told her that he had murdered 2 persons and cautioned her not to disclose this fact to anybody, otherwise she too would be killed, and on account of fear she and her husband had left their residence and shifted to some other place. We also see that the statement of PW7 recorded under Section 164 CRPC is almost in identical terms. It is therefore evident that the extrajudicial confession was made in a different background in as such that as the appellant suspected that he had been identified by the witness, he had returned to warn her not to divulge any information to anyone. The very proximity of the murder and the extrajudicial confession made to PW7 speaks volumes as to its authenticity. We also see from the record that the alleged murder weapon, a dao, had been recovered at the instance of the appellant. It is true that the independent witnesses of the recovery have not supported the prosecution, but we have no reason to doubt the evidence of PW12 on this score. Stop.